Welcome back to the Dispute.A podcast. I'm Paul, and this is episode 3. In the first 2 episodes, we mapped the pre-legal space and its boundary. This episode is about the mechanism that operates inside that space, the liaison desk. What it does, what problem it solves, and where its limits are. I'm going to be direct about this because Dispute.A operates a liaison desk, and there's no point pretending otherwise, but direct also means honest about the limits, because a description of a service that only lists its strengths isn't a description, it's an advertisement, and you'd be right not to trust it. The problem a liaison desk solves. Start with the problem, because the mechanism only makes sense against the problem. When an individual buyer ends up in a dispute with a developer, the two sides are not evenly matched. The mismatch isn't about who's right, it's about capacity and experience. The developer has a contracts team. That team has handled hundreds of disputes. They know the legislation. They know how the tribunals tend to rule. They know which buyer arguments tend to succeed and which collapse. They know how long an individual buyer can sustain pressure before fatigue sets in. The individual buyer has handled one dispute, this one. What the desk actually does. The liaison desk steps into the buyer side of the dispute and runs the pre-legal process on a professional footing. It starts with the legal position. It reads the contract, the relevant legislation, the documentary record, and produces a clear-eyed assessment of where the buyer actually stands in law. Not where the buyer feels they stand, where the law and the evidence put them. It builds the realistic outcome range. Given the legal position and the facts, what would a court likely do, and what is the spread of possible results? This is the shadow in which any negotiation happens. It builds the realistic outcome range. Given the legal position and the facts, what would a court likely do, and what is the spread of possible results? This is the shadow in which any negotiation happens. It identifies leverage. What can the buyer credibly do that the developer would prefer they didn't? A regulator, complaint. A tribunal filing. The documented, credible prospect of litigation. Leverage is what moves a counterparty who would otherwise wait. It runs the channel. The actual communication with the developer, the structured back and forth, the proposals, their responses, is handled by the desk rather than by the buyer directly. The desk communicates from experience rather than emotion, and the developer's team recognizes that they're now dealing with a structured process rather than an individual they can wait out. The asymmetry correction in practice, the single most important thing the desk does is change what the developer's contracts team sees on the other side of the table. Before the desk is involved, they see an individual. Individuals get tired. Individuals miss procedural steps. Individuals can be waited out, worn down, offered a fraction of what they're owed. After the desk is involved, they see a structured process that knows the legislation, has assessed the outcoming range, has identified the leverage, and is not going to get tired in the way an individual gets tired. That changes the calculation. That shift from individual we can outlast to process we have to engage with is the core of what a liaison desk delivers. Everything else is downstream of it. Where the desk's limits are now, the honest part. A liaison desk has real limits, and you should know them before you'd ever consider using one. A liaison desk cannot change the law. If the legal position is genuinely weak, no amount of structured process makes it strong. An honest desk tells you when your position is weak. A dishonest one takes your money to run a process that was never going to work. A liaison desk cannot force a counterparty to settle. It can apply leverage, but some counterparties will not settle pre-legal regardless. In those cases, the desk's honest output is, this one is going to need formal proceedings, here's why. A liaison desk is not a substitute for litigation when litigation is what's needed. When a dispute has crossed the boundary, a liaison desk's value is in recognizing that fact and saying so. A liaison desk cannot guarantee an outcome. Anyone who guarantees a dispute outcome is either misunderstanding disputes or misrepresenting them. And a liaison desk costs money. That cost has to be weighed against the realistic recovery. For a dispute where the amount at stake is small, the cost of a structured process may not be justified, and an honest desk tells you that rather than taking the engagement anyway, how the structure typically works. Most liaison processes are structured in stages, and the staging exists precisely so that the buyer isn't committing to the full cost before anyone knows whether the dispute is worth pursuing. A typical structure starts with an initial assessment, a review of the contract, the facts, and the legal position, producing an honest read of whether there's a case worth pursuing. This stage is where a buyer with a weak position should be told so before they've committed to anything substantial. If the assessment supports it, the process moves to the active liaison stage, the structured engagement with the counterparty. And the structure should include an honest exit. If the liaison stage doesn't produce a resolution, the buyer should come away with something, a clear evidence report, a documented position, a clear-eyed view of what formal proceedings would involve. The staging matters because it aligns the process with the buyer's interest. A process that assesses first, engages second, and exits honestly. If it fails, is structured in the buyer's interest. A liaison desk changes what the counterparty sees across the table, from an individual to be outlasted to a process to be engaged. That shift is the whole point. Everything it cannot do is just as important to know. What to take from this episode? A liaison desk exists to correct the asymmetry between an experienced developers contracts team and a first-time individual disputant. The asymmetry isn't about who's right, it's about capacity, experience, and emotional distance. The desk reads the legal position, builds the realistic outcome range, identifies leverage, runs the channel, and produces an honest recommendation at each stage. Its core effect is changing what the counterparty sees from an individual they can wait out to a structured process they have to engage with. Its limits are real. It cannot change the law, force a settlement, substitute for litigation when litigation is needed, or guarantee an outcome. The honest version of this service assesses first, engages second, and exits honestly if it fails. That staging is how you tell a resolution process from a sales process. In the next episode, we look at one of the most common and most painful off-plan situations, SPA cancellation, and the realistic outcomes when a buyer wants out of a sale and purchase agreement. Thanks for listening. The full transcript is at transcript.a. For pre-legal dispute support, dispute.a. That work is done.